Thank you all for coming out this evening. It's great to have you here. For those of us joining online, just a friendly reminder to please mute yourselves. It's just a wonderful honor and privilege to be here to be launching this inaugural lecture series, the Shapiro Distinguished Lecture on Global Climate Change and Energy Law. And so we are going to first hear from Dean Matthew to give some opening remarks, and then I'm going to introduce Dean Matthew briefly, and then we will hear our distinguished lecturer, Dr. Olawuyi, and then we will have time for Q&A, both in person and from our online participants. And then we will adjourn to a reception in the green wall next door. So that's a roadmap of what to expect this evening. I first wanted to say that it's been really exciting to work to put together this inaugural series. The support at UW Law has been fantastic at all levels of participation, all the way up to the dean and all the way through our ranks in the faculty and staff. So it's just been a privilege for me to be working with them, and having just joined in July, it just feels very much like home and a great place to call my employment. So very honored to be a part of this effort. So I should be getting pretty good at this. Just last night I introduced Dean Matthew, and it's going to be an ongoing pleasure to do that in all the events that we host in the Environmental and Energy Law program. So once again, it's a great honor to introduce Dean Damilola Matthew, and as the Dean of GW Law School since 2020, she's been here longer than I have, and I have been able to learn quite a bit of all the great work she did before I arrived, and witness firsthand all the wonderful things she's done since I joined in July. She is a leader in public health and civil rights law, and a passion for public service, and that's what is most near and dear to my heart. She's a real champion of the social justice issues that we seek to promote and build out in our environmental and energy law program. She's the first woman to lead GW Law, and she previously served on the faculty of University of Virginia School of Law. She co-founded and directed the UVA Equity Center, and that's something that she has also worked hard to launch something similar here at GW Law, the Equity Institute initiative here at GW campus-wide, which is just reinforcing that commitments to public service and equity. The mission is to create a university-wide research institute to support research and pedagogy that advances racial, ethnic, and socioeconomic equity in the U.S. and globally. And she has held a number of important positions in the policy world, in addition to being a fantastic administrator at GW Law, as well as being a prolific author and scholar, and author of the best-selling book, among many others, Just Medicine, A Cure for Racial Inequality in American Healthcare Law. And she is a graduate of some places you may recognize, the BA holder in economics from Harvard Radcliffe College, JD from University of Virginia School of Law, and a PhD in health and behavioral sciences from the University of Colorado, Denver. So I want to underscore that it's just been a privilege working with you, Matthew, to have her not only lead GW Law School in a very progressive and visionary way, but to be such a great supporter of the environmental and energy law program here at GW Law. So without further ado, it's my pleasure to introduce Dean Dan Matthew.
Okay, I know you really want to get to the speaker, so let me just thank you very much, Randy, for those warm remarks and introduction. I am just honored to welcome you to the inaugural J.B. and Maurice C. Shapiro Distinguished Lecture on Global Climate Change and Energy Law. This is truly a great occasion and a great launch to what I know is going to be a great evening and a great program. We are incredibly excited to launch this timely annual lecture series celebrating the work and leadership of Professor Arnold Wrights. Professor Wrights founded GW Law's Environmental and Energy Law program in 1970, and he directed the program for 38 years until his retirement in 2008. Thanks to his incredible foresight and leadership, along with the addition of some amazing new faculty members over the years, GW Law has been at the forefront of environmental law education for the past half century. Our program was established at the beginning of the modern environmental law era and continues to expand to provide the next generation of environmental and energy lawyers with the tools they need to tackle the local, national, and international challenges facing our planet and its inhabitants. I'm going to go off script for a second and say that I walked in and saw a series of graphic novels, a nice way to say comic books, that are about global climate change. I scarfed up a couple because I'm going to show them to my students and to my colleagues. And this is what I mean by making the climate change issue accessible and urgent to all populations. This is just one example. The Shapiro Lecture is an outstanding new addition to our program, bringing globally recognized leaders to our campus, and they will be addressing pressing issues in climate change and energy law. This lecture series is supported by the Shapiros, J.B. and Maurice C. Shapiro's Fund, which is generously supporting the Environmental and Energy Law Program Shapiro Symposium. The annual symposium, which is hosted by GW Law's Environmental and Energy Law Program, brings leading professors, policymakers, scholars, and environmental experts to GW each spring to address pressing issues of environmental and energy law. This year's Shapiro Symposium, which took place in April, focused on two pending Supreme Court cases concerning the scope of the Environmental Protection Agency's authority to regulate under the Clean Air Act and the Clean Water Act. We're now looking forward with great anticipation to hosting the 2023 Shapiro Symposium, which will take place on April 6th and 7th. Should be writing it down. The 2023 symposium will focus on how to improve our nation's environmental and national resource laws to reach the Biden administration's America the Beautiful goal of conserving 30% of the nation's lands and waters by the year 2030, 30 by 30. Speakers and participants will include environmental and natural resources management, agency staffers, academics, and NGO partners working in the important 30 by 30 goals. Please mark your calendars. Now, before I sit down, there are a few people I would like to recognize for their important roles in bringing us today's lecture. First, of course, I extend my sincere gratitude to you. A very warm welcome to our distinguished guest speaker, Professor Damilola Olawuyi. Have I done that right?
Very well.
I'm so glad. Thank you. From the Hamad bin Khalifa University School of Law in Doha, Qatar. Professor Olawuyi is an internationally recognized scholar in climate change and energy law and issues that will offer critical perspective on the search for climate and energy justice in the global south. You are most welcome, and we are most grateful for you being here. Next, I extend my sincere gratitude to the Environmental and Energy Law Program, our event sponsor, and our campus-wide event co-sponsors, GW Environmental and Energy Management, Sustainable GW, the Climate and Health Institute, GW's Journal of Energy and Environmental Law, and GW's Environmental and Energy Law Association. All of this, we also welcome our DC community co-sponsors as well. These are the Environmental Law Institute and the Center for Climate and Energy Solutions. Now, these aren't just welcomes. These are also thank yous for the incredible way in which collaboration across sectors, across disciplines, and across communities, because it's only through this collaboration that we will actually affect change in this issue of climate change and energy justice. Lastly, before I close, let me take a moment to tell you about a few exciting new developments and recent accomplishments of the GW Environmental and Energy Law Program. First, In recognition of the program's supreme importance, we've restructured its governance and this year appointed 2 leaders to co-direct the program. Now, turnabout is fair play. You made me sit there and listen to you talk about me, so now I'm going to do the same to you. This summer, we were delighted to welcome Randy Abate to the GW Law School as our new Assistant Dean for Environmental Law Studies. Among his many decades of accomplishments as an environmental law expert, Dean Abate has published 6 books and more than 30 law journal articles and book chapters on environmental and animal law topics, with recent emphasis on climate change law and justice. He brings 28 years of experience teaching, writing, managing programs, and mentoring students on domestic and international environment law issues. And in various contexts, he has done work including extensive international experience. We couldn't be more thrilled to have him at the helm of our environmental law program. Thank you for joining us. I'm also pleased to announce that our law school recognized the stellar leadership of Donna Atanasio by naming her an Assistant Dean for Energy Law, overseeing our energy law program and sustainable energy initiative. Dean Atanasio joined GW Law in 2013 as Senior Advisor for Energy Law, and after 24 years in private practice, she founded GW Law's Sustainable Energy Initiative. She is a gifted collaborator across the GW campus, working with faculty at the Schools of Engineering and Applied Sciences, the Sustainable Energy Institute, and the Equity Institute Initiative. Donna is also an accomplished scholar in her own right, working primarily in the area of electric utility industry and its transition to a more sustainable fuel mix. This balance is increasingly important as the world struggles to ensure equitable access to clean, environmentally sustainable energy and a healthy planet. Lastly, I'm also thrilled to announce that our new LLM joint degree in energy and climate law is a partnership with the University of Groningen in the Netherlands. Through it, LLM students are enrolled in this exciting new program to spend the fall semester in the University of Groningen and their spring semester at GW Law, studying energy and climate change and climate law under both European Union and United States law. GW's environmental and energy law program is proud to be forging all kinds of new partnerships across the campus, co-sponsoring events, partnering with the DC community, and around the globe, launching a new joint LLM program. Tomorrow, we are looking forward to hosting a post-lecture launch for our campus and the DC community. We will be discussing possible collaborative projects with Hamad bin Khalifa University and the law program in Doha, Qatar, the academic home of our guest speaker. These are exciting times indeed, and GW Law's environmental and energy law program are set for exciting success. I'm thrilled to have you come and join us. I'm thrilled to welcome you on behalf of the entire GW Law community. Thank you for being here.
Thank you so much, Dean Matthew. As you can see from that wonderful presentation of information, why I feel so much at home and how excited I am to be a part of this outstanding program. It's also a great privilege to introduce our speaker for this lecture series. Dr. Damilola Olawuyi has been a good friend and colleague for almost a decade now. And when I thought about who to invite to launch this series with the title Climate Change, Global Climate Change and Energy Law, he was the first name to come to my mind for a variety of reasons. And when I think about advising students about how to really make an impact in your career in this space, Dr. Olawuyi is someone who comes to mind right away. Because when I think about people I really respect in the field, I think about those who are making impacts on multiple levels, and that's absolutely what Dr. Olawuyi has done throughout his career. So he brings a rich background from practice as an energy lawyer in a very prestigious law practice setting. He has been a very impactful academic in a variety of places in different countries, currently based in Qatar, but also having a very distinguished educational background in the UK and in the US, receiving degrees from top schools, and also in an academic career in Canada. And then with all of that, most recently coming to Doha to really take a leap into doing something very different and impactful. And so I think a lot that goes into that ambition and creativity to join a program like where he is right now is his commitment to service and commitment to the importance of this field and how his role, his experience can energize people in a variety of different settings in a variety of different ways. So when I was thinking of putting together this lecture, I wanted it to be more than a lecture. I wanted it to be, for lack of a better word, an extravaganza. And so it is 3 days of very different ways of engaging with our distinguished guests. So a more socially oriented dinner last night was very productive to build relationships and appreciation for one another's work in the field. And today's lecture and reception more on the substantive side to really get energized about these topics and how we might interface with this field in our own lives and careers. And then tomorrow to really kind of close with deliverables from this great collaboration and put together some opportunities for partnerships to continue this very important and impactful 3 days together. So that was the goal, and I think I'd like to think that I found the perfect person to help us succeed in all of those efforts. And so certainly today's lunch with students was another example of Dr. Olawuyi's impact. It was a group of students who talked his ear off and engaged with him for a good hour and a half. And one of those students already visited my office to talk to him more after the lunch an hour and a half later. So it's just a great indication of the impact and the connection that he builds with both colleagues and students in his career. And he's certainly an expert on global climate and energy justice. That's what you're here to listen to. And I'm very delighted to introduce you, Dr. Olawuyi, to deliver the Shapiro Distinguished Lecture. Thank you very much.
Thank you very much, Randy, for the very kind introduction. The Dean and our H. Green Professor of Law at GW Law School, Dean Matthew, distinguished faculty and colleagues, friends of GW Law School, ladies and gentlemen, I bring you warm compliments and greetings from the state of Qatar in the Middle East, and it is, of course, my greatest pleasure to stand before you today as the inaugural J.B. Maurice C. Shapiro Distinguished Lecturer on Global Climate Change and Energy Law. Wow, it's a wonderful honor, and it's a beautiful day. Thank you so much, Dean Matthew, the entire law program, and of course, my great friends, the Assistant Dean for Environmental Law Programs, Randy Abate, for inviting me to be part of this milestone event in honor of the world-renowned Professor Arnold Wright, an academic giant who has exemplified the greatest dedication to energy and environmental justice throughout his distinguished career. I think the main reason why we are all here today is because of our passion for justice. The whole essence of law is to see that when there is a wrong, there is a remedy. And I think when I looked at the career of Professor Wright, especially his foresight as far back as 1970 to establish an environmental law program when only few people, even the UN, was not yet talking about environmental law at that time. We all know that the UN's effort started in 1972, the Stockholm Declaration. So it struck me as a wonderful innovation as far back as 1970 to be thinking of environmental law. And I think that foresight of Professor Wright created a worldwide fire in scholars like myself with a passion to then ensure a just and sustainable use of the natural environment and its resources. Like Professor Rice, I started my career first studying law, as Randy mentioned, in Nigeria, and then in Canada, I got my LLM, and then here in the US, another LLM, and then at Oxford in the UK with my DPhil. Like Professor Rice, I found the courage to establish Nigeria's first Sustainable Development Law Institute, which is now about 12 years old. And that led to my current role in Qatar, in the Middle East as the UNESCO chair on environmental law and sustainable development. So I think that passion for energy and environmental justice fits with what I have always sought to do, and I find great courage in Professor Wright's career. And I think today's event provides an opportunity for all of us to sit back and renew our dedication to justice. Law is about justice. So I've titled my lecture as The Search for Climate and Energy Justice in the Global South, because there are just a number of justice issues that I hope that I will be able to talk about within the few minutes that I have, if the clicker moves. Yeah?
No.
Okay. Okay.
Okay.
Is it good?
No.
Well, while we wait on the clicker, okay, thank you. I think one of the most basic human needs is energy. Thank you so much. Without energy, we definitely cannot process or distribute food, water, neither can we sleep or move around. So energy is so basic and fundamental to human existence that if there is a threat to energy, it should concern us as lawyers. Yet, in many parts of the world, we see the complex failure of law to ensure a just and equitable distribution and use of energy resources. This is 2022. Yet we have 1 billion people, 13% of the world's population, that still lack access to modern energy. In Nigeria, a great portion still cook with wood and coal dust. With all the progress that we have made in humanity, this is the state of global access to energy. You see that 85 million Nigerians lack access to electricity. And this is just talking about access. When you even then look at reliability, it's double. And same for India, Ethiopia. You see, the fact that in these countries, in Africa, for example, the continent of Africa, about 600 million people live without electricity, about 350 million, representing 9% of the population in Asia, live without electricity. Of course, while here in the US, access to electricity is not the problem. The real problem in the US is affordability. Studies and statistics by the Department of Energy show that 1/3 of American households cannot pay for electricity or lack. So there's the issue of affordability. And when you then scale down and look at the patterns, whether in the US or in different parts of the world, you see that that lack of access or lack of affordability is still tied to, in the US, you have low-income African-American, Latin, multifamily and rental households being unable to afford their own energy bill. Again, this is 2022. And then when you scale down further, you see that there's been programs in place for several years aimed at addressing these issues. You have the Low-Income Home Energy Assistance Program, for example, in the US, which has been around since 1981, which is meant to provide assistance to low-income families that cannot afford electricity bills. We have the Weatherization Assistance Program again around since 1976. Yet, less is known about their actual impact. The world clearly faces an energy poverty crisis. And I define energy poverty as the lack of access or inability to afford modern energy services and products. And of course, that is why we all talk about the United Nations Agenda for Sustainable Development, especially SDG 7, which places an emphasis on the need for all of us to achieve universal access to energy by the year 2030. But as we go on in the lecture, you find that there is global aspiration to achieve that by 2030. We're in 2022, we have 8 years to go, but local realization is still far off. But then this is not the only urgent crisis of our time. The world faces a climate emergency as well. Close to 2,000 jurisdictions and governments have now declared a climate emergency. The actual threats that climate change may shut down global economies, may worsen poverty levels, may worsen energy injustice, may create food scarcity, may worsen water scarcity. The direct impact of climate change are already appearing. Go to Tuvalu, go to Vanuatu, go to low-lying islands in African countries. In Africa, you find the fact that some are already shutting down their factories. Some can no longer live in their ancestral homes and lands because of climate change. Flood, droughts, cyclones, increase in extreme weather events. You have water scarcity in arid countries. I live in the Middle East, arid region, whereby even without climate change, water availability is already a problem. Most of the food we eat in Qatar is imported from abroad because it's an arid country anyway, so you cannot really cultivate food. So these problems are already there, and climate change is only going to worsen these existing conditions. Unpredictable weather patterns, land disputes as well. With increased competition for available land, there will be increase in land contests, land wars. But then I'm also worried by the indirect impact of climate change. You see countries developing projects, decarbonization projects, investing in climate projects abroad, and those climate projects are then leading to green capitalism. I was in Liberia the other time, and we were talking about the fact that when companies come from the West and they are trying to implement emission reduction schemes, they do it by seizing their ancestral lands. It's a green project anyway, but it is done at the cheapest rate possible, using cheap labor, violating rights to decent work and decent wages. And they said, Professor, is this the kind of climate justice or climate transition that we want? Or green energy transition, rather, that we want? Green capitalism, land grabbing, again, reminiscent of the problems of environmental racism that led to the environmental justice movement in the first place. Exclusion of women and youth from decision-making processes. And you find a lot of companies involved in greenwashing, which in law we describe as fraudulent misrepresentation, in which you say, oh, this is a climate project, but it's just repackaging a business as usual project and selling it to African countries or selling it to countries that may not be aware of this problem. And of course, transnational human rights violations by big companies. Again, I was in my visit to Liberia just very recently. And my engagement with local communities, they complain bitterly about how big corporations have taken over their destinies. And I said, what do you mean? They said, you know, there's an American company called Firestone that produces the tire that we all use for our cars, that has been operating here for over 100 years, violating their human rights. And I said, why? What's the government doing? They said, well, the government depends on the resources and revenue from Firestone. So the government cannot really do anything. And then you see some of these companies repackaging their existing efforts and saying it's a climate response. So climate injustice. We know that climate change is real. We know there is an effort to address climate change. But efforts to address climate change through decarbonization policies is creating climate injustice in many parts of the world that we may have to address. And in this table, I try to discuss some of the manifestations of or the justice questions in ongoing energy transition efforts. Distributive justice, procedural justice, reparation justice, social justice. Again, like I said, the aim of law is to deliver justice. So these injustices should worry lawyers. When you're talking of distributive injustice, you find that energy poverty challenges affect the world's poorest. There is uneven distribution of energy opportunities and burdens. Many of the communities where oil and gas resources are found are the worst in terms of education, the worst in terms of health, the worst. You cannot even, in my field visits, you want to go to those communities, but the roads are simply not available. But then all the resources are from there. Go to Peru, you find it. Go to Brazil, you find it. Liberia, you find it. Everywhere. And there are transnational corporations there. So the burdens of energy is unevenly, the burden of energy production is unevenly distributed. A UN report had shown that in Nigeria, for example, it would take 30 years to clean up some of the impacts of oil and gas operations by multinationals that have been operating there. And the only problem is that it will take 30 years, but the cleanup is not even progressive. Then you look at the issue of, well, there's endemic corruption and illicit financial flows as well, which makes it impossible for local communities where the resources are found to enjoy the benefit of these resources. We find the fact that many of these energy operations are based on a targeted attempt with governmental pollution to siphon the funds. Written reports already show that the amount of money that African countries have lost as a result of illicit financial flows is more than the GDP of several countries in 1 year. Yeah, you then look at the issue of procedural or participation justice, exclusion of people from decision making, especially women. Yeah, I have another one. No.
Enable it. Enable.
Okay. Okay.
Yeah.
Limited information on energy transition programs. There is also the issue of we want to achieve transition, but at what cost? For example, the International Labour Organization released reports showing that, well, if we want to achieve energy transition, it's good, but we must ensure that it does not lead to the complication of right to work, right to decent work. When you tell countries like Nigeria or other global south countries that rely 80% of government revenue still comes from the oil and gas. In Qatar, same. Across the Middle East, at least an average of 60% of government revenue come from these sectors. I am for transition, but I ask the question, how can we make it just such that 100,000 in one country that rely on income from these resources do not suddenly become jobless overnight because we are trying to transition? These are critical questions that lawyers can answer through research and analysis. Lack of local and indigenous content. You want us to achieve transition, but we still rely on imported technologies. several of which the local communities cannot even use and work with. And I have argued strongly that the United Nations should not focus only on technology transfer. There is a need now to consider technology absorption as well. How can we ensure that green technologies that are moved to the global south can actually be used? You find, for example, technologies imported from Germany into Nigeria, and every year the Nigerian government has to fly in German engineers to work the machine and service it and maintain it. So that lack of local content in technology transfer mechanisms is a huge gap, and I call for technology absorption as a solution. You have issues of restorative justice as well. The local communities feel the pressure of energy activities, but they cannot even afford the cost of litigation. If I check my mailbox every week, at least I receive about 20 requests, and I'm not joking, every week, from different local communities, whether in Nigeria, in Ghana or somewhere, saying, please represent us as our lawyer, just sue this company for us. No win, no fee, on no win, no fee basis. While I can take on some, I can't take on all, because then I don't know what will happen to me. And that just shows you that they want justice, but they cannot afford to pay a senior advocate that will go to court on their behalf. That should worry us as lawyers, that what sort of system of justice have we developed that those that need it the most cannot even afford it? Social justice issues. And some of these issues that I discussed, you find out that they build, the foundation for them is unresolved social justice problems in many societies. When the BBC released its report last year saying the energy industry is a men-only club across the world. It's a men-only club. And the statistics are damning. And then I go on the field and I ask on the board, why is it that there's no woman on your board? And they say, well, maybe they did not apply, or Are we talking about equity or equality? Because there must be a desperate and clear effort to ensure that we break down barriers to energy justice. And we cannot achieve energy justice without gender justice. Lack of gender-aware transition policies. We have policies that are designed to expand energy access. By the end of the day, those in local communities that rely on wood for cooking, most times you find that are women, and then you give energy subsidies that favor men in the formal sector. And that's because efforts to address energy transition, if we do not underpin them with gender assessment or gender-based vulnerability assessment, you find out that the benefits of transition will still go to the same category. Of course, we talked about land grabs. Another issue is the cosmopolitan justice dimension. And I was in the room the other day with a group of government officials, and I was, we're talking about this issue of energy transition. And they said, why should Africa and the Middle East worry about decarbonization when we did not carbonize in the first place? We are just trying to play catch up. We're just trying to open our first railway station. We're just trying to, open our first school in some communities. And you're saying, keep the resources under the ground. Never use your oil because you have to decarbonize. That is a justice question. Because how do we then ensure that these communities actually get out of poverty? Well, I'm a fan, I'm not a fan, I'm an advocate actually of climate justice, but I worry about the cosmopolitan implication as well. Because we want to achieve SDG on no poverty, we want to achieve SDG on decent work. Then these countries will need to then look for a way, if we are going to say, keep your resources under the ground, then we have to look for a way to provide other funding or mechanisms that will then stimulate the local economies. Otherwise, preaching the message of decarbonization to countries that did not carbonize in the first place is an injustice. And you see increasingly the EU and many other countries developing policies that say we are placing a ban on even environmentally preferable products. For example, the IPCC report describes natural gas as a lower carbon alternative, cleaner than oil, cleaner than coal. And developing countries that are rich in natural gas, such as Nigeria and Qatar, can they use natural gas as the basis for green hydrogen? My answer is yes. Or blue hydrogen? My answer is yes. And so I think it's an injustice, cosmopolitan injustice, I would describe it, when there are policies that are designed that do not really take into account the specific vulnerabilities and needs of developing countries. And of course, there is this debate, unending debates, and geopolitics of the transition. And the geopolitics of the transition is very, very simple. How can we achieve a safe, orderly transition that does not worsen the pre-existing conditions in developing countries? It is quite clear that climate and energy justice cannot be separated from wider social justice challenges facing our societies. They cannot, like I said earlier on, they cannot be energy or climate justice without gender justice, without racial justice. And you see that the global search is ongoing and has been ongoing. The United Nations Guiding Principle on Business and Human Rights, for example, tries to address some of these issues by, who can see this? Okay. By saying states and business enterprises must prevent, investigate, punish, and redress human rights abuse in all business activities. And this is an attempt to say, well, the focus on responsibility to implement climate and energy projects in a right-based manner should not be on state alone now. Even business enterprises have to play a role. And so the UN, endorsed these guiding principles and established a working group on business and human rights to implement it. And I'm a member of that working group. And now we're increasingly putting pressure on business enterprises, saying you have to then have a justice plan to show that your efforts to address, whether it is in the energy sector, in any sector, your efforts to invest is not complicating human rights situations on the ground. You have the Inter-American Court of Human Rights, for example, also saying, well, climate change violates human rights, and states have an obligation to ensure the participation of persons subject to their jurisdiction in decision-making and policies that could affect the environment. Of course, the African Commission has also recognized some of these problems. African states have to put in place measures to achieve public participation, accountability, access to information, non-discrimination, and the likes. At the EU level, we have instruments that talk about the need to incorporate human rights in all impact assessment on an ongoing basis. And of course, you have soft law initiatives. A number of banks have adopted the Equator Principles, saying that, well, we will not give you financing for any project if you cannot show that you are implementing environmental, social governance frameworks. You have the UN principles on responsible investment, and a number of other, the report on the tax force in the UK, shows clearly the need to address ESG. And even at the domestic level, in the United States, for example, you have the National Action Plan on Responsible Business Conduct, which tries to say, well, efforts to invest abroad must not violate human rights. Of course, we see that in most cases, you see litigants coming to US courts under the Alien Tort Act, trying to say, well, this entity, this US entity invested in Nigeria and Liberia and they violated all my human rights. But the real problem is, can these local communities afford even the flights to come to the US to sue under the Alien Tort Act? So this National Action Plan is recognizing some of these challenges and is trying to say, to put that consideration at the start of operations in the first place. And you have this, due to the UN guiding principles, a number of other countries are implementing this National Action Plan. So the global search is on, and these efforts aim to achieve what I describe as the panel principles: increased participation of local communities, accountability, non-discrimination, empowerment, and access to information, legality, and access to justice. The whole idea is that our search for energy transition should not complicate human rights. And to be able to do that, we must ensure that we focus on human rights due diligence, risk analysis, to ensure that all members of the public that will be affected by a project actually have the opportunity to take part and influence decision-making process. So these panel principles try, they summarize, I would say, some of these old global norms. But my key question is, how are these global norms translating to local reality? The answer is not much. We have these huge and high-sounding principles at the international level, but local implementation remain very, very weak. And that's in many countries, especially in global South countries where institutional quality may be low in the first place. You cannot talk of integrating human rights into energy projects when there is really, really no respect for human rights in the first place. And I think developed countries have roles to play in this. Why should the United States continue to trade with developing countries that have no respect for human rights? These are all global issues. These are all big issues that should concern us. So you find that some of the gaps that remain, absence of climate change laws, I've mentioned absence, lack of respect for human rights. We cannot talk of climate justice when there is even no climate recognition in the first place, or when there's no climate law. And you find that, a global study conducted by the Sabin Center at Columbia shows that only very, very few, as a matter of very, very few countries in Africa and the Middle East have any legislation on climate change. Lack of an energy justice plan or energy poverty plan, even not measuring the amount of people with access to energy. These are all challenges that make it difficult for us to make progress when it comes to taking those big principles at the international level and implementing them locally. You also have a situation whereby when we talk about climate and energy justice, it is a natural mix of climate law and human rights law. And then you go to energy institutions and they have no expertise on human rights. They tell you categorically, I'm sorry, go to the Human Rights Commission. It's not my duty to talk about human rights. And I said, well, but you were the one that gave the approval for this project. So I'm sorry, I'm an energy expert, I'm an energy ministry. I have no business with human rights. This fragmentation of legislation, fragmentation of responsibilities result in incoherent outcomes for energy justice. And of course, it breeds lack of cooperation and interoperability. And this lack of interoperability was evident during the COVID-19, for example, in which we find people trying to say, well, I need access to health facilities, it's my right, but I have not had electricity. And they say, well, you're talking about two different things here. It's not related. And I did a search. How many legislation across the world, energy laws actually do reference human rights? None in many countries. I did a search in African countries. How many legislation talk about just gender, energy law, like this is the petroleum law of this country, gender, search for gender? None. Search for human rights, petroleum licensing law, search for human rights? None. So these are big issues. And it's clear that not integrating human rights into legislation on energy may have worked in the past, but will not deliver a just transition. Because it will simply mean that energy institutions will continue to implement their energy policies without any need to consider justice or human rights concerns. Some will say, but there are other laws that provide for these things. But the truth is that when it comes to implementation, when the implementing authorities have no knowledge of the justice gaps and have no training to consider these issues, the outcome will always be an unjust outcome. And of course, we have gaps in data collection as well. I gave examples of the situation in the US, for example, in which these programs have been around for a while. And you ask the question, what is the impact at the local level? Now, In many countries in Africa and the Middle East that I have done field studies on, you see a lack of clear data on the number of people that have been, that have access, number one, to energy, that have access and that have benefited from energy programs. So I think lack of that statistical data, inability to be able to even search on government website and find this information is a breeding ground for energy injustice. Well, in terms of what constitutes good progress, a study did ask the question, how many countries, when developing their SDG planning, refer to these principles? These principles, according to the UN, represent good progress. Human rights-based approach, intergenerational responsibility, leaving no one behind, it talks about equality, planetary boundaries, respecting, ensuring conservation, energy efficiency, universality, which we'll talk about incorporating all human rights, whether it is social economic rights or civil and political rights. And what do you see? The yellow shows that of the 50 countries, 39 did not talk about universality in their SDG reports and in their SDG planning. Planetary boundaries, 46 did not even reference it at all. Leaving no one behind, equality, very good. Almost all countries talked about that. Intergenerational responsibility, implementing programs that will protect the rights of future generations. 29 did not talk about it. Human rights-based approach, deliberately shaping energy and climate policies based on human rights norms. 43 did not talk about it. This shows the gaps that still remain in energy policy and planning. Not referencing these principles show that we are trying to make progress on the SDGs, but we're not doing it in a right-based, just, and inclusive manner. In conclusion, it is clear that efforts to address development concerns, such as delivering clean, affordable, low-carbon energy, may complicate human rights situations unless we deliberately put in place appropriate safeguards. And I say that these things are recurring problems. Anytime there is a plan or anytime there is a global effort to achieve development, it often results in worsened human rights situations, especially for low-income and vulnerable groups. And you can go back to the problems of environmental racism that led to environmental justice movement, the problems of climate exclusion that led to climate justice movement, and now, again, energy transition and energy justice movement. So development efforts, the burdens of development should not be borne by a certain vulnerable. International law, we can only define good progress in international law as our effort to achieve a just, inclusive, and right-based response that will not leave anyone behind. So there is a need for a mix of structural and non-structural reforms to address some of these issues. Of course, by structural reforms, which will mean things like having energy and climate smart infrastructure investment scaled up to defeat energy poverty and to enhance institutional operability through technology. Again, I talked about the need for interoperability amongst institutions. I talked about the need for even technology absorption in developing countries. It's not enough to continue to transfer technologies, but empowering the local communities to develop their own homegrown solutions that can help them to be able to make progress in terms of defeating energy poverty. And of course, there is a need for non-structural measures, such as putting in place laws, policies, and rules to promote ESG outcomes in climate and energy actions and projects. And of course, there is a need for education and awareness For many years, law as well as human rights education focused a lot on the role of non-state actors. And the message we are now preaching at the UN level is that the focus must shift now to business enterprises as well, who are responsible for most of the shocking climate and energy injustices across the world. So I say there is a need for ESG focused programs that will educate business enterprises, LLMs, SJD, executive programs that will educate business enterprises. You know, I grew up studying law and there was so much emphasis on public law. But what about non-state actors? How can we ensure that we prepare them to implement human rights due diligence approaches that will address some of these justice concerns? And I think today's lecture is a good example of the ideas cross-fertilization that is urgently needed to promote climate and energy justice in the global south. I think DW Law School's strategic location in Washington, D.C. makes it a natural hub for international law and global affairs. So we very much look forward to joint programs that will enable future business leaders and policymakers in Qatar, Nigeria, across the Middle East and Africa to work closely with their colleagues here to understand and address these issues. Ladies and gentlemen, I must end by saying a big thank you to the organizers, Randy, Donna, Rob, Emily, Joe, the volunteers, and everyone that have worked tirelessly to ensure the success of today's lecture. I say a big shukran, which means thank you to you. Thank you.
We're able to take your questions here in the audience or online. Dr. Spooner.
So first, let me thank you so much for joining us and thank you for the very thoughtful words. I apologize, but I'm going to offer a rather, I don't want to say depressing, possibly a cynical question for you, just to challenge. Thank you so much. My fear in all of this is that justice doesn't resonate the way that it used to. And my greatest concern is that people are just selfish. And this is what we see in a lot of the political movements that we see. I'm reminded during the COVID pandemic, there was a striking article from a policy standpoint, which is, I don't know how to discuss the pandemic with you if you don't care about other people. So I love the fact that you talk about the UN SDGs. My experience in the United States is Americans aren't familiar with them and they don't have the bandwidth to care about all those different things. They only care about themselves. So here's my cynical question for you in terms of rubrics. We saw the economists push for the carbon tax because it was a single metric and the suggestion was it was value-based. My specialty is government contracts, and I see the global best practice on fighting climate change congealing around life cycle cost analysis, where we try to internalize the externalities to make prices reflect the harms they cause. But again, it's trying to reduce it ultimately towards it's worth it in terms of the money, not that we should actually care about other people. So I guess my question to you is it feasible for people to actually care about justice, particularly when we know that climate change is about wealthy industrialized countries that have caused it and are better able to mitigate, better able to adapt to it, and the folks that didn't cause it are the ones who are suffering. So I apologize if that's unhelpful, but thank you again for joining us.
Thank you. Thank you.
Yeah, you can address that. Sure.
Well, you know, I totally agree that the real problem is that entities, especially business enterprises, are set up for profit anyway. So the concern is about our margins, you know, in as much as, I mean, I've had meetings with CEOs and they'll tell me, well, I agree with everything you're saying, it's okay, but at the end, we're not a charity. We're here for business, and this is business. But my approach and my response has always been, that argument was tenable some years back, but now with the whole UN focus on responsible business conduct, there's now a strong business case in terms of risk management, in terms of reputation management, to begin to consider some of these issues and go beyond that profitability mindset and start saying, how can our business activities and enterprises positively influence the local communities where we operate? It is not my business it's not my problem as a business if the government in a country is not doing its own job. That was a good argument before. But now, it's just part of risk management to begin to now say, how can we use our operations to positively influence the lives of local communities in accordance with the UN guiding principle? I hope I answered your question. Thank you.
There's a question in the chat.
Oh, let's see.
Can you press at the top?
Wait, up of the screen.
Oh, okay. To the extent that you feel comfortable answering the following question, I would love to hear your perspective. Well, I knew this was going to come up. With the World Cup in Qatar, there's been a lot of focus on working conditions. And Fred, I would love to hear your perspective on how we can start to put justice first in putting on global events such as this. What environmental justice lesson can we learn from Qatar World Cup? And even though I'm not in Qatar, I'm not watching the World Cup, this question still came for me. It's an important question, I would say. And it's a question that everyone in Qatar is taking seriously. And I know this because I've lived in Qatar for 7 years. And I've had discussions, I've had consultations with the organizers, some of the organizers and the people playing key roles. But what I find, so I agree that there is a need to put human rights at the center of organizing mega events such as the World Cup. There is an urgent need, there is a clear need. Is Qatar realizing this? The answer is yes. Is Qatar making efforts to address this? The answer is yes. Now, are the efforts enough? There is always room for improvement. And this is not something that I alone realize. Everyone realizes this problem. But the context must also be set straight. And this is my own personal view. When you look at when you understand the situation on the ground, you see that there's been the amount of labor reforms that the country has embarked upon over the last 7 years is beyond what I've seen in any other country. The intense reforms of labor laws just to address some of these issues. So, but then you see another dilemma. Qatar's reforms seem not to be enough. But there are questions about the fact that, again, I talked about this whole idea of cosmopolitan justice. This is a developing country that is trying to make progress, that is trying to build its infrastructure, that is trying to at least build railways, build, and is successful in hosting the world. And then developed countries are saying, don't do this, don't do that. Some will argue that most of the progress made in the United States, made in Europe, are made from the perspective of labor abuse as well. So, of course, that's not a good argument to say, well, continue to abuse labor rights as well. But I think developing countries should be assisted rather than condemned. That is my honest view. Developing countries should be assisted with labor reforms, Developing countries should be assisted with human rights training. Developing countries should be assisted with technologies to measure human rights problems, but never condemned. Because condemning developing countries that are just trying to escape the resource curse, that are just trying to escape poverty, creates a whole lot of problems. Qatar is not recruiting labor for free and saying, come and work and you will not be paid. No, I live there. People are paid. The argument is that human rights respect is not enough. And a lot of people will say yes to that. So I think what we should focus on is that, assistance approach to enable countries such as Qatar that are making genuine progress to continue to make. Now, that is my own honest view. So the answer is yes, we should continue to assist through human rights awareness, human rights education. And I think, and I've looked at the progress made in the country, and I think the World Cup is going to leave a legacy of that labor reform. That will be one of the biggest legacies of this World Cup. Labor reforms and sustainability legacy. That will be, and if that happens and it's happening already, I think that will be a big plus. I hope I answered your question, Jordan.
You mentioned some of the islands in the Pacific that are disappearing under the ocean because of sea level rise that's linked to climate change. And that raises the issue of climate migration. And there are some people who are concerned that there's going to be massive migration of populations from countries most adversely affected by climate change to countries where situations and circumstances are not quite so dire. So my questions are, do you anticipate a climate migration catastrophe in the coming decades? Is enough being done to prepare, both in the countries that are expected to generate refugees and in the countries that may be asked to receive them? And if not, what can be done to better prepare for that imminent problem?
Thank you very much. That's very important, and it's a wonderful question. You see, the problem of climate induced migration is already a big issue, and there's been a number of cases that the UN Human Rights Commission is even looking at in situations in which people were fleeing Tuvalu and Vanuatu due to climate change, and they got to Australia or they got to New Zealand and they were turned back because the law there talks about receiving refugees, but it does not clearly mention climate refugee as a form of refugees that should be accepted. So these issues are ongoing. And I think there is a need to recalibrate international law, to start recognizing that, to expand the scope of refugee law. I mean, there's a non-refoulement principle of international law anyway that says you should not turn back someone who is fleeing from danger. But the argument that climate change is not a danger may be correct 10 years ago, but definitely not now. But the problem is that implementation remains weak because in as much as we know, there's still that lack of clear and express recognition of climate-induced refugees as part of international law. There's been a number of, scholarly work done on this, and we believe that with time, countries will start by clearly mentioning climate-induced migration as part of their, laws relating to accepting refugees. I think that is really, really important.
Let's see, we've heard from two faculty members already, Professor Wexman, Professor Schooner. I see Dean Solorio had her hand up. I want to make sure we get a student question. So let's go here.
Thank you. Following up on that question, actually, in your opinion, for the land that's already been essentially ruined and devastated by the climate change, what happens to climate refugees who can no longer return to the land when the energy has already been absorbed and transferred to the countries that they fled from? The land has been ruined, so what can they do now? And what obligation do developed countries have to those climate refugees?
So what should happen in those countries whereby there's no recognition of climate-induced migration, and you have to turn back countries, you have to turn back refugees? What should happen? I guess that's the question.
Like when the land is like there's no hope for the land anymore. Like even if you fix climate change and fix the energy, you transfer it all, these people can't go back. So what happens to that land? What happens to those people?
Well, it's the interesting thing is that international law sets these principles. What we realize is that at the end, the implementation is local. And that's why there is still a clear need at the local and domestic levels, really, to clearly, to recognize this whole, number one, climate-induced migration, providing specific and clear indication of how it will be dealt with. Number two, providing clear and express provisions on reparations, such as the one you talked about, because it's one thing to say, well, go back. It's another thing to say, where do we go back to? And what you find is that efforts to come under existing laws, like environmental laws, are not working. Because the question will be, well, we recognize your problem, we recognize your pain, but this is not part of our jurisdiction. This is not part of what we were set up to do. So the approach of fitting climate concerns into existing laws is not working in many parts of the world. So there is a clear need to start creating express, reparation and compensation frameworks that will enable those that are displaced to be resettled, to come back. And I know that Professor Abate has written a number of articles on that.
Dean Florio, we may have to conclude with that question.
Well, first of all, thank you so much for your lecture. I actually had a question for you on international law, and also
Yes.
basically I work in the human rights field, and we're following very closely the litigation before international bodies. But one big question also is the treaties, right? How to use the treaties. And as you know, there's been this debate, very lengthy debate over, do we really need to codify that right to a healthy environment globally, because we do have some codification regionally, and also, do we need more treaty provisions that are more specific when it comes to climate change? We know we have some new treaties like the Escazú Agreement, et cetera, but I wanted to ask you what you thought of this, if you think that we need more specific treaty provisions on climate change, or whether the treaties that we have are enough. And I know you're working with business and human rights. I wanted to ask you what you thought also of all the discussions related to the treaty on business and human rights.
Yes.
And the push for it as well. Thank you.
Thank you very much. Well, in fact, I've been one of the strongest advocates for a specific and separate right to a clean and healthy environment at the international level. And we've been pushing for that for several years. There's been problems with how do you define such a right, who are the right holders, who are the duty bearers. But there was progress just over the last few months, in which the UN General Assembly actually indeed endorsed that there is indeed a right to a clean and healthy environment in international law. That's progress that took many years, but we are getting there. The next piece of work is how to then take that General Assembly recognition and then translate it into a legally binding treaty that we can then hold and say, well, you have just violated my right to environment. Will that happen? I believe it will happen with more pressure. It will take a while for countries to agree to such a treaty. And that answers your second question with the legally binding text on business and human rights as well. I mean, since 2011, there was a guiding principle. There was this UNGPs. So you would think naturally it should lead to a legally binding treaty. But we are in different rounds of trying to agree to that legally binding treaty. But I think if we can achieve these two instruments, legally binding treaty on business and human rights, and of course, a clear and express recognition through a treaty that says there's a right to environment, I think we have made a lot of progress in having instruments that we will be able to use and invoke to hold businesses and entities to account. Right now, though, there is the Paris Agreement, which again mentions in the preamble that, well, everyone should ensure that when taking action on climate change should respect human rights. So that's still something to use, at least for now, while we continue to work on these other two instruments.